Hello, and welcome to the first ever episode of The Legal Scoop. My name is Brendan Shannon. I'm an attorney with the law offices of Melissa Day, and this is our new video series that we're going to be releasing once a month where we go over some notable wins out of our firm. Our first guest, and I think she's honored to be the first ever guest, is Cassie Christman. Go ahead and say hello, Cassie.
Hello, my name is Cassie Christman, Associate Attorney with the law offices here in Melissa Day's office.
And Cassie, I understand that you had a pretty notable win recently involving the recent Blue decision. So, to start off, why don't we just go over what was the issue of your case and maybe even talk a little bit about the Blue decision?
Yes, so the issue in my case, it was a scheduled loss of use matter. The claimant had a wrist injury, inclusive of the ganglion cyst, which I'm sure, as you're aware, as well as others watching this, that the ganglion cyst actually is a special consideration explicitly delineated in the impairment guidelines. The ganglion cyst in and of itself is worth 0 to 7.5% schedule loss of use. Well, as you touched upon, there was a recent decision from the third department earlier this year, actually, the matter of Blue, which had come back regarding a knee special consideration of chondromalacia. Now, the matter of Blue had come back with the range of motion deficits being able to be added to the chondromalacia finding for the schedule loss of use in that matter. Now, the goal with my case was to somehow differentiate, obviously, between the matter of Blue and what was occurring in my case. Well, taking a further look at the matter of Blue, the third department actually was not finding that just range of motion deficits could be added to a special consideration of chondromalacia, which prior to it has been argued by every carrier that chondromalacia in and of itself restricts the schedule loss of use, and range of motion deficits cannot be added in addition to the schedule loss of use, which is delineated in the guidelines. Because as everyone is aware, the guidelines explicitly directs you to apply special considerations prior to anything else, and only if a special consideration is not applicable. And also, it says in the special consideration that other deficits can be added, then no other deficits should be added. Well,
Right.
the matter of Blue kind of threw everyone for a loop because in that case, they did allow for additional range of motion deficits. However, taking a deeper dive into that case, the claimant in that matter also had meniscal tears. Now, as everyone might be aware, meniscal tears are not given a special consideration in the impairment guidelines. I believe they were prior to the revised impairment guidelines, but they are not in the new impairment guidelines, 2017. So, the meniscal tears are actually a separate diagnosis not accounted for in the special considerations, which were contributing to this claimant's range of motion loss. The board, therefore, allowed additional range of motion loss because there was a separate diagnosis causing the range of motion loss, which is not a special consideration, to be accounted for with the chondromalacia special consideration. As you might be aware, claimants everywhere thought that this was going to be an open area now for special considerations to be applied in addition to range of motion deficits. And that's exactly what happened here. The matter of Blue case was fresh off the press, and claimants counsel in this matter thought it was an opportunity to have the claimant's doctor add range of motion deficits in addition to the ganglion cyst special consideration for the wrist, because the doctor originally had done that in his opinion. However, when I had argued it at the in front of the law judge did find that the claimant was not allowed to add those additional additional range of motion deficits to the ganglion cyst. So after arguing to the board that the difference between the cases is that in the chondromalacia case, you have two separate diagnoses: the chondromalacia, or the matter of Blue, I should say, I should reference it as its case. In the matter of Blue, you have the chondromalacia and you have meniscal tears. Chondromalacia was accounted for, and they thought that limiting the claimant from a separate condition which was caused by his injury and which resulted in range of motion deficits would be prejudicial to the claimant, and that was not what the guidelines intended to do. With my case, the argument was made that the ganglion cyst was the only diagnosis that was accounted for, and therefore there should not be any additional range of motion deficits added because the ganglion cyst special consideration in and of itself provides a range of schedule loss of use to be awarded, which is 0 to 7.5%. So it was our position that that in and of itself does account for range of motion loss. The worse the loss, the higher the schedule loss of use, a 5% versus a 7.5%. The board actually agreed with that analysis. They had agreed that in the matter of blue, there is two separate diagnoses, one of which is a special consideration and one of which was causing the claimant to have range of motion deficits, which is not a special consideration, and therefore they allowed the range of motion deficits to be added. They actually noted that in the case that I had won at the board level, that the matter of blue was displaced and it was not properly interpreted by claimant's counsel, in that this case there was not two separate diagnoses, and you're not going to be able to account for range of motion in addition to a special consideration across the board, which is huge for carriers, as you know, because again, this was kind of an open field day for claimant's counsel to try and get in every instance range of motion added to a schedule loss of use that has a special consideration which applies. And we kind of put that, we immediately out the gates had that appeal and were able to win that appeal, and found out that the board is thankfully interpreting it the same as the carriers are. So that's a big one, because it is, again, it's a very recent third department decision, and it still was up for interpretation at the time that we submitted our rebuttal.
Wow. Well, Cassie, that's a fantastic win, and I'm really glad that you were our first guest for the Legal Scoop, because it really, I think the way you approach that case shows the attention to detail that we pride ourselves in here at LOMAD, and it shows that while everyone just sort of assumed that the blue case was, like you said, going to be open season as far as schedule loss of use awards go involving special considerations, that we took a look at it and found a way to maybe rein it in a little bit and avoid just getting special considerations with range of motion loss added on. So congratulations, that's a fantastic win. Thank you for being our first guest on the Legal Scoop. And for those of you watching, we will be back the same time next month with more wins.
Thank you, Brendan.